And I'd like to welcome Dennis on behalf of the Henry Ford Health System Care Program. Dennis, thank you so much for being here. And you can go ahead and get started. Thanks, everybody. Just please remember to keep yourself on mute. We will be recording so you can view this session later. Also, there will be time at the end for questions. So you can either put your question in the chat and I can read it when we get to the end of the session, or if Dennis feels it's appropriate, he'll answer it during the session, but we will take the questions at the end. Thank you.
All righty, and now I'm going to try to share my screen. Let's see how this goes. Okay. And is everybody able to see like estate planning for the future up on the screen?
I can see it, Dennis, yes.
Okay, perfect.
Yep.
That's my thing. Let's try to get it started there. There it is. Okay, much better. And so basically, good morning, everybody. Glad to be here. We've done 2 of these over the spring, and I enjoy doing these. The one thing is that I always talk about is that first, I don't practice this type of law. I don't do estate planning. So I know the basics, of course. I've been to law school. I'm a licensed attorney. I do some family law, which is custody, divorce, things like that. And so basically, this is an overview. So I'll get to my conflict of interest statement and all that good stuff that Henry Ford requires in just 1 minute. But first, under the disclaimer, the presentation is given for educational purposes only, and there's no attempt to give legal advice or any information obtained shouldn't be taken as that. This is basically an overview presentation just to make you more aware of things. It's always best to consult with somebody licensed who concentrates in the area and who can specifically address all of your specific concerns. So at the end, I'll put up Ruby Legal Solutions. I make no referral fees, no money, not a dime. But the place I send people to is Amy Ruby out of Southfield. She does a great job. I've never had anybody displeased with her service whatsoever. She's really good at it. And so I send everybody right over to Amy. After the last presentation, I know there was quite a few that went to her and everybody was very pleased. So we'll talk about things as they, I guess, develop as they go along. And you'll see kind of what I'm talking about as we progress. Let's see. All right. Sorry, that was my disclaimer statement. I have 2 slides in front of me. So there's all the stuff I just talked about. Now we'll go into about me. First, I'm an attorney. I'm admitted in the state of Michigan, as well as the federal court here at the Eastern District. I run my own law practice. It's just me. I have no assistant, no paralegal, no anything. Most of my practice is in criminal defense. I handle everything from murder to the traffic ticket. And I do some family law, which is custody, divorce, parenting time, all that messy stuff. So that's kind of like one of my jobs. My other job is in our system, Henry Ford Health System, and I'm emergency preparedness coordinator. I'm at the Sterling Heights campus on 15 Mile and Ryan Road. There's an emergency department, a freestanding emergency department. We don't admit patients there, but we transfer them out if they need admitting. But we're a full-scale ER, handle everything that comes our way in there. And so I'm designated by Henry Ford to actually deal with what I call doomsday scenarios, end of the world stuff, I call it, but basically stuff with chemical, biological, nuclear, explosives, all that good stuff. And most recently, of course, is the COVID response. So, of course, we all lived through that, and I did quite a bit through the COVID issues to lead our response out there in Sterling Heights. My other background is retired police officer. I did that 15 years. I went to law school during the day as I worked at night as a police officer, worked during the day or went to school during the day and worked evenings at Henry Ford. It was quite a bit of 3 years. I still don't know how I did it. And also I've advanced EMT, used to work in the city of Detroit 911. So I did quite a bit of stuff there. So I've got some well-rounded experience within a lot of different things. You can see the education stuff. But basically, the big ones are the law degree. And of course, that didn't quite hit the spot, I always say. So I went back to get a master's in public administration. A lot of what I dealt with was fiscal and human resource management and then nonprofit. Basically, because of Henry Ford, I did a lot of the nonprofit organizations and management and things like that. So it was quite interesting. And I really actually enjoyed that degree, actually working on that. So getting to the presentation itself, who needs an estate plan? Well, the first thing is everyone. The first piece of advice always is don't fall into the I'll get around to it. So a lot of people say, yeah, I'll get around to this, I'll get around to that, and things don't happen. Sometimes things happen and then there's no time to do that. So a lot of people were going to get to it, they don't get to it. I deal with a lot of family law clients. There may be a divorce, there's an inheritance, somebody dies during the divorce, then there was no plan in place, and then we have to bring the probate court into it, and there's quite a bit of heartache and a lot of stress. So a lot of times just getting to it as soon as possible is a good thing. Even if it's simple as writing out handwritten, I want to leave everything to whoever, sign it and date it. That's better than nothing. So we'll get into a lot more about estate plans themselves and what they entail or what they could entail in just a minute here. So the purpose of planning is the following. First is that you want a big say in what happens to yourself, for your loved ones, your assets, when you can't. A lot of people, once you're incapacitated or you pass away, you have no more say, obviously. And so a lot of times it turns into a big squabble. And even if it's not a squabble, it could leave those left behind looking for what did you actually want. And through different conversations, people recall things differently, or things change over time. So you might say something to one family member, something to another friend within a 6-month period. And so now they're confused, and it's not that they're trying to squabble or fight with each other, but their issue is that they don't know what you actually wanted. So the purpose of planning is to have that say in basically what you've worked for and accomplished and where you want it to go. It sets up a structure to minimize any of these conflicts, as we just talked about. There's some good techniques that you could have a smooth transition of assets without involving a probate court, needing a court order. And we'll talk about some of those, such as joint bank accounts, joint, deeds, things like that for houses. The added bonus to a lot of this is inventorying your assets. A lot of people don't know what they have, so they actually have to sit down and write it out. Sometimes they forget about, oh yeah, I have that, that ring from grandma, or oh yeah, there was that couple shares of stock that somebody left me years ago. I totally forgot about that. So a lot of times with planning, you get an actual very good bonus, because then you actually have to look at exactly what you have and to actually plan for where you want things to go. Now, if you don't plan, here's the different consequences. First, basically the probate judge gets a big say, including what happens. This includes if you have children, minor children or disabled dependents, including guardians of those children. So a lot of times having a will or these documents in place will actually benefit you in who you'd want to continue on to raise your children. People they don't know who you'd want to be in charge. You can designate somebody to be in charge. If you don't have a will, the law writes one for you. So basically the legislature has an estate plan for you if you don't have one for yourself. Basically the law kicks in. It's of all things, it's called EPIC, right? We all hear about EPIC, but it stands for the State Planning Code in Michigan. And basically, if you don't have a will, the law kicks in and it divides your assets according to the law. And so basically the legislature is determining where your stuff goes. Assets can end up with people you don't expect. There's certain things you can do if there's certain family members or people you would not want to get anything from your hard work over your life. They could end up with something. Just if you didn't have a will, the law says they get it, they would get it. If you did have a will that said, nope, specifically that does not go to that person, then they surely wouldn't get it. So assets can end up with people you don't expect or don't want to have. So that's another consequence of not planning. And then the other one is assets can be distributed to your children before they're ready. So sometimes if you have younger children, and not just children like under 18, but if there's something transferring to your kids that you don't think would be quite, responsible at that point. I don't know, when I was 19, I don't know if you put X amount, $20,000 or something in my hand, if I would have been the best person to manage it right away. You can have documents where they have to do certain things, or they have to wait a certain period of time to get things. For me personally, and I use myself as an example a lot, just to by way of illustration, is that I have no kids, but I have nieces and nephews, and they're, I got nieces and nephews from 17, literally just started college, all the way down to a 1-year-old. And having all of them, they each get a lot of what I've earned. But the big thing is they're not allowed to touch anything. They don't get any money because it has to be spent on education. The only way they get their hands on anything, if I were to die today, is to spend that money on college or job training, something educational. They don't get it. I always say they're not going to, they're not going to get it to drink and party with. So that's one thing I just do in my documents just to make sure. Once they get their bachelor's degree, everything gets released to them. So that's kind of how I have my stuff set up. Or if once they become 35 years old, if they haven't obtained a bachelor's, then they get their money. So that's if something were to happen to me. But that's something I want to make sure is in place so I know that what I've earned and is going to them isn't just going to waste. A lot of times too, there's tax advantages to estate planning, and if you actually are doing if you have a lot of assets or significant assets, tax planning is very essential to make sure that more goes to your family and less potentially to the government. Loss of privacy, that goes down to the probate court. So if there's a big protracted dispute over anything, it goes to probate court. Everything's public record in our court. So there is a lot of loss of privacy. We can all see from, who was it? I think it's Aretha Franklin. I think there's a dispute on her will. And the media just waits for filings. They actually have services that look every day to see something new was filed to her case just so they can report on it. So a big loss of privacy there. But I mean, that could be, for anybody in that case. And then family member disputes over assets is much more likely once you have, if you don't have something in place. So what does it actually include? Well, the first thing is a will. We've all heard, about a will, and that basically says once I pass away or once I die, we basically have, this is where I want my property to go. This is who I want to raise my kids. This is who I want to administer my issues. So that's the most common estate plan document that people have. The other one's what's called a revocable trust. And what a trust is, it's basically a fake entity. It's a fake person almost. And it's a creation of law that says this person or this entity gets funded with money. So you put assets into it, money, property, whatever it may be. And then somebody can live off of that trust. There's a trustee that has to administer it. But basically, that's another way of dealing with it. Normally with a trust, you have to have assets to put into it. So a lot of people say, yeah, I want to do a trust because I don't want my family to deal with probate. But a lot of times they don't even have enough property to put in the trust to even administer it. So trust isn't really an option. So, but once if you do have significant assets or, want to deal with the trust and you consult with somebody who's going to actually write an estate plan for you, that's one option. The other one is the durable power of attorney as well as healthcare. Durable power of attorneys for your financial matters, healthcare is for your healthcare choices. At Henry Ford, we have forms that we have that people can fill out, including the advanced directives right under there. And a lot of that is so that if you're incapacitated, your family members can make decisions for you. It also has your wishes on what you would like them to do or what you want done, such as I don't want heroic measures or, do everything, full code status. I want CPR, I want everything. Or, you know what, if you lose a pulse, lose, respirations, then I don't want anything beyond, beyond anything such as the basic CPR. You try to bring me back, but I don't want to be on life support, long term. So you can create that whatever you want. That's the best thing about estate planning is it's what you want, and you can tailor it to your needs. The other couple things in here that are less common is the memorandum of trust and disposition of tangible personal property. That kind of goes along with the trust documents. Retitling of assets. That's such as if you have, say, a house and you want your house to say go to your son or daughter. Say you're not married. You want it to go to your son or daughter. You can retitle your assets so that they're a joint tenant, it's called. So joint tenant with rights of survivorship. And what that means is if somebody passes away, the other person automatically is the owner. Nobody has to go to court. It's automatic. So as an example, in my case, I own my house. And what I did is I'm not married. I don't have a spouse. I don't have kids. And so what I did is my mother is on the house with me. So I'm an owner as well as my mother, and we have joint tenancy with rights of survivorship. What does that mean? That means if I were to pass away today, my mom automatically is the owner of the house. She doesn't have to go to probate, doesn't have to transfer anything. At the moment of my death, she's the owner of the house. No questions. That's not an issue. Same thing. If she passes, the owner is solely in my name. We've actually done the same thing with her house so that we have that where we don't have to deal with probate court. So that's one way you can retitle assets. The other way is bank accounts. A lot of times, if somebody passes away, the banks can be a pain because they want to make sure everything's very on the up and up, T's are crossed, I's are dotted. Because if they're wrong and they give away money to the wrong person, they're liable. And so a lot of times putting a family member on the bank account with you now is a good thing, because if you pass or they pass, then the money's right there. It becomes property of that person, and they can administer things without having to deal with the court. So the other issues there is beneficiary designations, guardianships, and life insurance, revocable trust. One thing I will caution everybody is there's something called pre-will documents, and life insurance is one of them. So your beneficiary on your life insurance is who is going to get your life insurance assets. Even if you have a will that says somebody different, the life insurance beneficiary is supreme for your life insurance proceeds. So if you have person A on your life insurance, but in your will, you have person B is supposed to get your life insurance proceeds, doesn't matter. Person A is going to get that. So make sure all of your documents with Henry Ford within your retirement, any life insurance, disability insurance, anything we have through Henry Ford, if you're a Henry Ford employee, you update that. If you're employed elsewhere, make sure that's updated if you have life insurance or any of these other type of programs, so that your basically your life insurance proceeds will go to exactly who you want. Where there's no will, you have no beneficiaries, no guardian, no personal representatives, no trust. So basically the legislature gets to determine who gets your stuff, and when there's no will. Now the will itself is just directing how those assets are going to be paid after your death. Parts of that is the personal representative, and what that is somebody who's going to administer that will. It does not have to be an attorney. A lot of times it could be a family member, a child, husband, wife, parent, uncle, a friend. It could be anybody. And so you get to designate who you want to actually carry out the terms of the will. The other thing which we talked about earlier was guardians. You want to appoint a guardian if you have minor children or disabled dependents. The court will ultimately, on guardians, will have that say. They ultimately have that say based on the best interest of the child or the dependent person. But your wishes go a long way in putting that into your documents. So that's very important. That's the most important part of people who have minor children. That's the most important part of most of their wills, is that. The other one is a testamentary trust. They call it Q-tip trust for spouse, family. That's a technique where if one half of the marriage passes away, everything goes to the other spouse while they're living to take care of them. And then when that's done, then it gets distributed. So that's another technique. In Michigan, certain requirements must be met to qualify as a will. The first thing is a signature. The second is a date, 2 witnesses, and is what's required. Now, the other thing we have, and yes, the slides will be emailed to you in PDF format. So that was a good question that popped up. So these slides will be emailed to you. So don't worry about writing all of this down. I send these out, Veronica and then Sean, they email them out to all participants. So you don't have to write that out. I should have said that in the beginning. So I'm glad somebody popped in with that question. So with these, with the will, that's generally what you need is you need your signature, the date, and the witnesses. Now, we have in Michigan, we actually respect holographic wills. And what that is, it's a handwritten will. So that's why I said earlier, you can write out a statement. I want everything to go to whoever in my handwriting and date it. And that's actually valid even without witnesses because it's in my handwriting. That's why I said that's better than nothing. Now, generally, I don't recommend that only because, we have better ways to do that. So everything's more planned for. But I've used one before. I was getting on a plane, to go across the country. And one of the family members who was supposed to take basically, if I were to pass away, was to get some of my assets. And when I looked, I went, oh my God. And literally, it was hours before my flight. And I thought about it. And I did not want their descendants to get anything. And I knew under the law, that's how that would work. And so I just did a quick amendment to my will in handwriting and signed it to state they're no longer in the will. And that was just to make sure that my mother and my sisters and nieces and nephews got pretty much everything because that other family member had passed away. And so holographic wills are respected. They're valid in Michigan. They're just, generally not the most recommended thing unless you're in a pinch. Below that's a document, the peace of mind document through the legislature that gets into a lot more details of a lot of these different things. So that'll come out in the slides, so you can go ahead and take a look. There's a PDF document. I think it's 50 pages, quite extensive information. Guardians, of course, that we've already talked about, but guardians are somebody who steps in as kind of the parent if you pass away. So the guardians, you can designate guardians, the first person, your first choice, your second choice, third choice. I've seen it where there's been 8 choices. 8 choices listed right out there. Here's my first choice, 1 through 8. This parent wanted to make sure that her choices were respected. She had a complete order for exactly who should take care of her kids. So guardians are listed right in there. Now with a revocable or living trust, a lot of this stuff, it's a lot more flexible. It protects a lot of assets. There's different things. Again, that's that fake, not a fake entity, but it's a fake person, I call it. It's like a corporation. You create this entity to put assets into. And so I call it a fake person because it's not a real person, but it's an entity where you can put a lot of your stuff, your house, your cars, whatever the case may be. And then a lot of times it gives you some tax advantages and things like that. It does not create any asset protection, though, for the creator. So that's a big thing. A lot of people think, well, I'll just put all my assets into a trust. If I get sued, I'll be safe. That's not necessarily the case. So that's an issue. The other one is a pour over will. And that's basically if you put everything into a trust, whatever you don't include, you can include in a will that says, hey, whatever's not included, this goes to this person. So again, there's a bunch of different documents in here that you can use to accomplish your goals. And it's got to be tailored specific to you. I've got a chart up here, will versus revocable trust. There's advantages to each. There's the X marks there. But a lot of times with the will, you could kind of see some of the things is the avoidance of probate is the number one concern of most people. They don't want to deal with the probate. A lot of times that's not a real issue. Even if you do need to deal with probate court, is because most probate issues are informal. Family member files an informal probate. Nobody's contesting. The family works things out in 28 days. Everything's starting to get dealt with. And there's certain, just court documents. You need to transfer a house or transfer a bank account, whatever the case is. And there's no real big issue. It's called an informal will. Now, if there's a contest or somebody contests the will, then that gets a little more complicated. You get a lot more, issues included. So there's a lot of stuff including in those, and that's going to be in the slides when you get them at the end. Trustees for an actual trust could be yourself, family members, friends. You could hire a professional to do it, a CPA, an attorney. It could be a beneficiary, could be an institution, could be one of the guardians your kids would administer it. Whoever you choose is in there. Generally, they just have to be 18 of sufficient ability to handle being a trustee. Beneficiaries, where's your stuff going to go? Most people use their children or other family members. Charities is a big one. A lot of people donate to charity at the end. Could be friends, could be family. It could be anybody. I personally have a person at Henry Ford Health System who we're not actually friends, but this person is in my will because there's certain things that I would like him to be able to do educationally that I don't think he has the ability to do because he's tied down with some things. So if I were to pass away today, he would actually, he's a Henry Ford employee, a coworker and he doesn't even know. So he'd be surprised if I were to pass away today, that he would have some money for education to kind of let him not work to finish what he needs to finish. So that's a very big thing. It could be anybody. That's just one example. It could be, I don't want anything to go to my family. It could be, I want everything to go to charity. I want everything to go to the Diabetes Association or whatever organization you pick, it can go to. There's been wills before where people have donated certain actual pharmaceuticals, if you can believe that, and specifically for certain cures or something. So, I mean, it can go to anybody. Anybody can be that beneficiary. Now, if you have a revocable trust, you got to make sure it's funded. And so that's a lot of the things we talk about is if you have, say $1,000 in assets, you're really probably not going to set up a trust. That's more for significant assets and things like that. So you just have to make sure it's funded. There's stuff to actually put into the trust. If you had just, certain things, normally a will is the best way to go. Now, a big thing outside of the trust and wills is a durable power of attorney. Separate from that, that lets people handle your financial matters, financial documents. And so you have these things that if you're incapacitated, somebody can deal with your bank affairs, pay your bills, things like that. Financial matters are handled by what's called attorney in fact. And that's something that always comes up because how many people see on TV, somebody says, Dennis Whittie, attorney at law. And everybody goes, well, duh, attorney at law. Of course you're an attorney at law. What other kinds of lawyers are there? Well, the truth is there's attorney in fact. And so attorney at law are those who are licensed to practice law, but an attorney in fact, attorney is just somebody who acts on somebody else's behalf. And so financial managers are handled by your attorney in fact. So if say your son or daughter is your durable power of attorney, they're actually your attorney. So an attorney in fact to sign these documents and do what needs to be done. It can become effective immediately. You could sign on today to say, oh, I want my son, daughter, friend, parent, spouse, whoever to make these decisions for them. You could sign away right today to do that. Even though you're sound mind, you don't want to deal with it, they'll handle it. You could do that. Most people wait till they're incapacitated to sign over that type of power, but it can work, whatever is to your circumstances. The same thing too, it can provide for nomination of a guardian or conservator. It's kind of the same, same as attorney in fact type situation. So, and the other thing is important for assets not owned by a trust. So if you don't have a trust, and most of us don't actually have a trust, so they can handle very basic things that come up. I know I have somebody her daughter just passed away a couple weeks ago, and she has the power of attorney now to deal with her daughter's financial affairs, and she had them while she was at end of life. So she could sign different things, pay her bills, pay bills out of the bank account to make sure things were maintained and to handle things. So durable power of attorney is a very useful tool, even while you're still alive, to handle things. And I had hernia surgery back in June. And one thing I did is before I was put out, I had a durable power of attorney signed. I had my medical power of attorney. I had everything done. And that was so if something happened where I couldn't make these decisions, somebody could actually take care of things, including my dog, because I have a dog at home. And I want to make sure she was taken care of. So like I said, it's tailored to everybody's circumstances. The other power of attorney that we deal with is the health care. And that's so somebody can make decisions for you when you can't. It applies to the HIPAA. We all know about HIPAA. It's drained in our annual competencies if you're a Henry Ford employee. But HIPAA is, we know is the confidentiality type law in essence. And it deals with health records. And so most people can't deal with your health records, but if they have a durable healthcare power of attorney and they need to make decisions, they can access that as soon as, provided that there is an actual healthcare power of attorney and everything is done correctly. And Henry Ford themselves has forms for this. So it's all spelled right out in there. You can handwrite them out, sign them, get them witnessed, and turn them in. It can be right part of your epic medical record right with Henry Ford. But it basically authorizes any Henry Ford or any other hospitals, if you're part of Beaumont or St. John's or whatever health system, it allows them to speak and share information with your family members to make decisions on your behalf. Advanced care directives, I think a lot of us are familiar with that. Generally, let me just start off, that can be anything. You can state whatever you want in your advanced healthcare directives. And so the three basic ones are terminal conditions. If, say, you're diagnosed terminal within 6 months, you don't want any measures taken, they won't take measures, to prolong your life. Or persistent unconsciousness is another very common one. Irreversible coma, basically brain dead vegetable, a lot of times it's called, or just end stage condition, where you said, when I pass, I want to pass. This could be anything though. You can say, you know what, I just don't want to be on a feeding tube. So don't allow a feeding tube, or I just don't want to be on a vent, but I do feeding tubes just fine. So either way, whatever it is, it's tailored to what you want. So advanced directives for healthcare is very, very important to actually choosing what happens to you, not your finances, not your property, but for you. Again, these are some of the things that I just kind of went over, end of life choices and what they can actually sustain and what they can and can't do. Statement of property at the very end. It's basically a part of a trust that you specifically want certain property to go to somebody after you pass on. So if you have a trust that says this bank account or this stock or dividends from this stock, whatever it may be, is going to go to this family member. But then after I pass away, all the residual goes to somebody else, or all the jewelry goes here. That's kind of like a statement of tangible property, kind of like the pour over will that we talked about earlier. Beneficiary designations. Again, this is probably one of the most important parts of the presentation. Remember, we talked about pre-will beneficiaries, retirement plans, IRAs, 401k, life insurance. These are all pre-will documents. So on your IRA or 401k, if you have person A and then in your will you put person B, it doesn't matter in time. It's whoever's on that retirement plan is going to the one who is the beneficiary. That's the one who's going to take. That's the one who's going to get the asset from that retirement plan or that 401k. Some of us have a retirement plan plus 457s and all kinds of different things. And you could put different people on different ones. That's fine, but just know those documents must be updated. And so if you're a Henry Ford employee, you generally have to update everything in November. That's a real good time to look over all your documents. It's November next month when you're updating all of your I guess benefits. That's a great time to look over all your documents, make sure things are up to date. If you're not a Henry Ford employee and you have a 401k, take a look at it, pull it out. Have a designated time once per year just to take that out and take a look to make sure that beneficiary is still who you want to get, the proceeds if you're to pass away. So there's all the other stuff listed on the slide that we've kind of went into. But a lot of this stuff is exactly to make it as you want. But again, a lot of the pre-will documents, the life insurance, the IRAs, the 401ks, that stuff itself is going to be, that's separate. That's not part of the will. So you can think I'm going to write out a will and everything's fine, and that's going to deal with that issue, and it's just not. So make sure all these documents are up to date. Another tip or technique is to retitle your assets. Now, this just kind of depends on your situation, but if you have a house, like I talked about earlier, my house is in my name and my mother. We're joint tenants with rights of survivorship, and we do that through a quitclaim deed. And you just do that. It's very one-page document. You file with the county where the property is located. There's certain legal requirements, but that's a way to make sure once one person passes, the other one automatically has that asset. That's an important thing. That can go to deeds, that can go to bank accounts, that can go to anything at that point, because that's a very easy tool to use and important. Now, one way you might not want to do it is if the person you're going to put on your house or your car, whatever the case may be, if they are subject to a bunch of liability with creditors, or they're in the middle of a big lawsuit where they're getting sued, that may not be the best time to put them on your house, because that may subject that your asset becomes theirs, and that may subject you to some collection issues. So again, if you're going to do that and you're going to do an estate plan, talk to a specialist in that area. Other entities that are used, these are less common, but you can use them as limited liability companies. You can set up your own limited liability company to put your assets in and administer it as a company. People do that to protect their assets, different things. Sometimes it's a technique that works extremely well for people, and sometimes there's just not enough to put into it. So it just depends on your circumstances. Other ways to limit your liability is liability insurance, or what sometimes is called umbrella insurance. So we have life insurance, car insurance, property insurance, but there's other flood insurance sometimes. There's another insurance called liability insurance umbrella policy, and that says basically it's an umbrella over everything. In case you get sued, you have up to X amount of dollars of coverage. So a lot of times that's going to be liability insurance. And the best part about that is generally once you have that policy, it pays it. And I'll go over irrevocable trust for sure. But it pays for a lawyer. Generally, if an insurance company is getting sued with you, they provide the lawyer because, well, they don't want to pay out. So that's kind of an advantage to having a big liability insurance policy. We've already talked about the minor children with appointment of the guardian and disabled child. So even if you have somebody who's 18 or over, you may want to make sure there's a trust set up, even in your will, to say if I pass, there's a trust set up now with a trustee to divvy up assets and to make sure this disabled child is taken care of. This could be somebody under 18 or over in that case. Life insurance, we talked about that. It's pretty, liquid. Money gets paid out. You're not worried about selling different things. And then, there's some of the other things to consider in here, which we'll go kind of over in questions because I saw a question come up. What is probate? Probate is something that transfers assets and deals with creditors. So once you pass on, that's what probate does. It kind of takes your stuff and divvies it up according to the law. And then the process is pretty, I talked about the informal process, but pretty much everything starts with a petition to have the will of the personal representative appointed. You nominate that person. Generally, the court's going to go with your nominee unless they're incapacitated. But there's an asset list they write out, they put in the court, give a notice to creditors, any heirs, beneficiaries, all of that stuff. They have to pay any income or estate taxes, if any. Chances are you won't have to pay the estate tax, and I'll get into that in just a minute. Pay any debts off, distributions, and pay off anything, finalize accounts, and close the estate. That's kind of in a nutshell. This could be formal or informal. Most of them are informal, as I talked about earlier. What assets go through probate? Anything that's you're held at death, real property, mineral interest, bank accounts, whatever. What doesn't go through probate? If you had your house in your name and say your daughter's name, and you had joint tenancy with rights of survivorship, the minute you pass, that house is your daughter's. Therefore, that doesn't go through probate. It's her house already. So that's not going to get probated. Same thing with a joint bank account, or if they're jointly on the car together, things like that. And yeah, we already just talked. I actually jumped the gun on that before the slides. So all these issues don't go through probate. The other one is down here that we didn't talk about is a life estate. And that is if, say, I pass on and I say, the house that I own will go to my sister for her life. And then when she passes, then it gets sold and divvied up. So a life estate is to grant something to somebody for their life to make sure they're taken care of. Then once they pass, it goes on. They don't actually have ownership over that asset because my estate owns it. But once they pass, then it goes to the people I wanted or gets sold off or handled however I planned it. First rule in estate tax planning. So there's a unified tax credit. And so the big thing is, so everybody hears on TV a lot of times the death tax, right? We hear about the death tax. Oh my God, they want to tax all your assets. It's the death tax. The funny thing about that is one of the most disingenuous things. Unless you have, this is back in 2015, it was $11,800,000 is exempt. So unless you have over $11,800,000, your family's not going to be subject to the death tax. And this has really been, really skyrocketed over the years. It used to be $600,000 in the 90s, and it's gone up. So basically, unless you have this kind of money, which is great, and kudos to you, you're not really going to be subject to a lot of that. So most of the people, when you transfer things, you're going to take care of this unified tax credit. This also applies to gifts given during your lifetimes. So if you say you had money and you give something as a gift, they can claim the credit as not as income, but it counts towards your $11 million. So as long as you're not going over $11 million as of 2015, and it goes up each year, that's That's how it works. The exclusionary or the exclusion gifts is it allows you to gift $50,000 to somebody without a tax penalty. So unless we're moving some major cash, and I don't have that kind of cash for sure, it's really not going to affect you a whole lot. Between spouses, though, that's another thing. This allows, basically, there's an exemption between spouses, so you can transfer your spouse without tax penalties. There's just a form when you file your taxes, 706, that is dealt with, that has to be filed. A big thing is organ donation. Things to think about now, if you want to be an organ donor, don't just include it in your will and not say anything. The best thing to do is if you want to be an organ donor, Michigan Secretary of State has something for the back of your license you can fill out. Tell your family members what you want. I would put it in the will as well. I would put it in my, what is the end of life advanced directives even. I mean, wherever you want to put it, make sure it's known, because obviously we know that if we want to be organ donors, there's limited time to be a donor. And again, that's all your choice. If you want to just donate, say, your heart and your lungs to somebody who may need that, that's fine. I have a friend who donated everything to science. She said, it's my body. I don't care. I want do whatever you need to do to help advance science and make medicine. So she's not donating her organs to somebody. She's donating everything right to science. So, I mean, these are all your, all your choices. And again, the Gift of Life number is down there. The Michigan Secretary of State website has something. But the big thing is talk to your family, because when things are happening, they happen in hospitals, especially end of life. And then a lot of times the families are left to choices on what to do, whether you want an autopsy, whether you want to donate organs, things like that. Certain times the law requires an autopsy, many times it doesn't. And so I had an ex-girlfriend when her dad passed away. We were at Beaumont Hospital and we were trying to make a decision on should we do an autopsy. And it was hard because he never really said what he wanted. So that was a hard decision for her and her family to make. It's pretty gut-wrenching. And we went back and forth for a good half hour on what to do on something like that. So having all of these things noted for your family is extremely important. Okay, so on the tips, we've already talked about the taxes, advantages, the joint tenancy with rights of survivorship. We've talked about that extensively. I do want to give you one story. I generally don't do this kind of work, but I knew a senior citizen in a city I worked for, loved her to death. She was a restaurant owner. I ate there all the time. Very sweet lady. I was going to law school at the time, and she said, well, when you get through law school, I want you to do a will for me. And I said, okay. So once I became a licensed attorney, it'd been a year or two, and she said, well, let's do this will. So I did her will for her. It's a very simple will. And one of the things she wanted was she had 3 children, adult children, and she was almost 80. And when she her actual assets, I told her, you have to make sure you transfer your bank account. You have to take your one son off of that. Otherwise, he automatically gets your bank account. You want that evenly divided. We're going to put that in your will, but I need you to go to that bank. We need to get you there so that you can, take his name off. It's just your name, so that your will provide for it. And she was very nice. She wanted everything to be equal. So she actually had property and everything. She divided everything up very nice. But she had a substantial sum of money in her bank account. And she said, okay, I'll get to it. And so her one son, who was taking care of her at home, was going to get her up there. And she said, yeah, I'll take care of it. Well, after we did this will, within 2 weeks, she passed. And when she passed away, she'd never gotten up to the bank. And so the son who had that money on that account, do you think he split it? No, he literally went 2 days later, as soon as he could, and he cleaned it out. Actually, it wasn't 2 days. It was literally the next morning. He walked, withdrew all the money because he could prove she had passed. And he was jointly on the account. He didn't need to prove that. He withdrew all the money. The will didn't mean a hill of beans because that he was joint, he was joint tenancy with rights to survivorship. So that's a story I always tell people to say. Those things are very heart-wrenching, and that's a lesson learned. And her other 2 adult children lost out on some significant things to help them, only because the assets weren't playing according to the law. We tried to do it, but things happen as they happen. So it's a very useful tool, but at the same time, if you have somebody on that as a joint tenant, that's a real issue too. And a lot of times once you put them on that account, such as a house, they're owners of the house. They have to sign off. So make sure if you're going to do something, it's your son, daughter, whoever it may be, or friend, make sure that's somebody you really want on that joint property. So as I say, it's a great tool to shield you. It's also something that could hurt if things are going bad. So I just want to give that. Same thing with bank accounts, mortgages. Big thing with financial scams. The biggest thing going around now is Facebook. If you're on Facebook, people send you messages that say, "Hi, how are you?" Whenever you see that garbage, that's a fake account. They take the picture of your friend there, then "Hi, how are you?" Then they talk about, "Oh, I'm trying to do this, I'm trying to do that." My mom had somebody who was a coworker send her, "Oh, I got this. I don't want you to miss out, Diane." All this stuff. Now, my mom knew it was a scam, and she had fun. She's retired, so she had fun. She's back. How do I do it? She wasted this guy's time to no end, and she didn't give any information whatsoever. And she kind of had fun. She goes, "Well, I had nothing else to do today. Why not? I screwed with a scammer." But the big thing is delete those things. The other scams are people who actually come to the house, knocking on the door. Don't trust anybody's coming to the door to sell you something or look at your bills, things like that. Just really watch, because those are getting very, very more and more prevalent. Emails that come out. A lot of times you can tell by misspellings in the words, or the calls that are coming out now from, "Hi, there's an IRS and there's a warrant for your arrest." The IRS doesn't call you with warrants for your arrest. These are some very basic things that a lot of people would say, "Oh yeah, that's a scam," but people fall victim to them all the time. And so, especially people who are picking up the phone saying, "Oh, well, your son or daughter," they get information, say your son or daughter who lives out of state is in need of money and they're incapacitated. And so they get people, especially senior citizens, to wire money and then clean out accounts, things like that. So watch the financial scans with that. The other thing is keep written records of everything. I say keep a folder or a big envelope, something in a filing cabinet at your house or wherever, just to keep everything together. I always recommend that, because I keep mortgage together with my car title, with my life insurance, with my will, everything. And I told my mom, this is where it's all kept. And my sisters all know too. This is where everything's all kept. And this is the file name on my computer. This is where you go if you need this, but there's redundancy for me. And make sure your family knows where those records are. So that's extremely important. Now, again, the information that's provided is Ruby Legal Solutions. Amy's out of Greenfield, out of Southfield, Michigan. She's who I send people to. I send family members to Amy. And again, I don't make anything off of her. I don't make referral fees, anything like that. I just know she's really good. I've known her, 10 plus years now. And I know she's extremely competent attorney in this area. And that's why I send everybody to her. So if you have really specific things for your situation, she's the one to sit down with and really do estate planning. And of course, I got the caveat in there. It's best to have a licensed attorney draft these documents. But in the meantime, if you want to write something out, handwriting, that's better than nothing. So with that, I will take some questions. Let me unshare my screen here.
Dennis, thank you so much. This is Veronica. So what I'd like to do is just have everyone stay muted. How about if I read the questions in the chat first? Because those might answer some people's questions, and then we can go forward after that.
Okay, that sounds great.
So I'm just going to scroll through to go back through to see what the questions were.
Okay, perfect.
Okay, so let me know when you're ready. If you want to, you're still sharing your screen, so.
Oh, am I? Oh, let me unshare.
Yeah.
Try to find that. Unshare. You can tell I'm a Zoom person. Stop sharing.
There you go. Perfect.
Much better.
All right. Well, thank you so much. I really appreciate that presentation, and we'll do the questions in the chat, and then afterwards we'll take some questions if people have other questions. So the first one is from Gail Talley, and it says, can a will still go through probate?
Yes, actually a will itself will go through probate. It's the trust that doesn't. So a will get probated. If you have a will, that's normally it can be an informal or formal, okay? But it will still go through probate. The thing that doesn't go through probate is the trust, or if you have those joint tenancy with rights of survivorship. But yes, it still would go through probate. Definitely.
Thank
Good
you.
question, though. Good question.
Good one. So this next question is from Angela Kusik, and it says, if a home is retitled to include an adult child, does the mortgage balance negatively impact their debt ratio and their credit report now?
Good question. So remember, the mortgage is different than the title. So if the child's not on the mortgage, it's not getting reported out to the credit agency. So it should not have any effect on that. Now, if your child is on the mortgage with you, if you have to remortgage and put that person on the mortgage, then yeah, we'll have some credit report implications. But if there's a mortgage and you're responsible for the mortgage and you put your child onto the house as a joint, joint tenant with rights of survivorship, that should not be getting reported out. Now, the caveat to that is the mortgage company may have something in your mortgage, or your insurance, your property insurance may have something that says you may have to add them on. You have to check with your insurance carrier. So that's something to look at. Unfortunately for me, my house was a fixer-upper, so I paid by check and fixed it up. So I don't have the mortgage with me and my mom, so it's really just done. And my mom's house is already done, paid. So we don't have those issues. But yeah, if you definitely check with your mortgage company to make sure there's no requirement. The big thing is with insurance. You don't want something to happen and then give the insurance company an excuse to say, oh, no coverage because you didn't tell us, or something like that.
Thank you. Thank you so much. Great, good question. So the next question in the chat is from A. And A says, for years, professionals and others have recommended a trust. I still don't see the benefits of a trust since I have clearly stated beneficiaries listed on all accounts and a Lady Bird deed on the house. I want assets to transfer immediately upon death. Why do I need a trust? Would a trust shield beneficiaries from taxes?
Good question. Okay, so basically, if you have, and I'm looking at your question as well, and if you have beneficiaries on your accounts as joint tenants, then maybe a trust isn't even necessary for you, because nothing's going to go through probate if you have whoever you want on your bank accounts, or on your titles to your cars, your homes, whatever the case may be. And you also have a ladybird deed on there, so that's fine. And then you want assets to transfer immediately upon death. If you have them on as joint tenants with rights of survivorship, that's already happening. So trust may not be the option for you. Some people who don't want that. So say they have a son or daughter, whoever is creditors, and they put them on the house. A trust may be the way to go for them, and then there could be a shield from some type of taxes. Now, that again is going to be specific to your situation. That's why I say, especially in that thing, if you have, it sounds like you have ladybird deed going, all accounts, a lot of stuff going on. So something specific to your situation to sit down with somebody who plans in that would be probably really useful to you. But in the meantime, it kind of sounds like you may not need a trust. I personally don't have a trust myself. I don't find it the most useful for my situation. So a lot of people want the default, oh, I need a trust, I need a trust. A lot of times trust isn't even the most beneficial. And it sounds like in your case, it may not be.
Thank you. So the next question is from Vicki, and it says, listing a charity as a beneficiary, typically a social security number is requested. How to get around this and list the charity?
Okay, so I'm just double checking.
It was at 11:40 from Vicki.
Oh, yep, saw that. Okay, so I think the question is how to get around giving them a social security number, I think.
Yes, yes.
Okay, so basically, and I'll be honest, I'm not exactly sure the answer to that question, because you can list the charity as the beneficiary in your will documents, but I don't necessarily know they're going to need your social security to do that. I have two charities in my will, but I don't list the social security, and it's supposed to be distributed to them upon my death. So I'm not exactly sure what situation you ran into, Vicki. Not quite sure why that is, but I don't think you're required to give Social Security unless you're doing it while you're living and you want it for tax purposes. They want to give you a receipt for that. So if you're doing it now versus at your death, and you want to get the charitable deduction, which they severely, they kind of limited in the tax code. I'm not sure. Upon your death, you have to give Social Security number. Could be while you're still alive if you're doing it just to get the tax credit. But I think I'm getting your question, but I'm not quite sure of the answer.
So this is Vicki. Can I jump in? What I'm trying to ask is, like on a Henry Ford account, I currently have a niece listed, and I have to list a Social Security number to save the page. So what if I want to take this niece off and give that particular account to a charity? I can't save the page because I don't have a Social Security number to list, is what I'm asking.
Oh, thank you. That clarifies it. That makes a lot more sense to me now. Okay, you can tell it's struggling. Okay. If that's through Henry Ford, Vicki?
My example is.
Oh, okay. The best thing to do is whoever you're doing that through, whoever you're donating, a lot of times putting in all nines is the default code for charities.
Oh, okay. I never thought about that. Never thought about that. Thank you so much.
Oh, no, absolutely. That if you're doing it on the system, now I get your question much easier. Try putting all nines in or all ones in. Sometimes that's a default. That'll let it go right through.
Okay, wonderful. Thank you.
Yeah, absolutely. Great follow-up. Thanks for chiming in.
And then Pavan Reddy had written, will you go over irrevocable life insurance trust?
Okay, and I saw that one during the presentation.
Yeah.
Glad we're circling back to that. So the difference between revocable and irrevocable is revocable means I can create a trust and put whatever I want into it and whoever can take, but I can change that because I can revoke it. I can take it all back at any time. Irrevocable means once I sign everything away into that trust, it's irrevocable. I can't take it back. So that's the big difference. So if you dealing with life insurance, the life insurance itself is the policy. It's not exactly a trust. So we're combining two things in here: irrevocable life insurance trust. Your life insurance itself would go to that person. Now, if you want to make that irrevocable for whatever reason, you have to deal with your life insurance carrier on that, but I'm not sure if they actually permit that. But you're going to have to deal with whoever you deal with your life insurance on, because generally you can change your beneficiary on your life insurance. As a matter of fact, if you're married and you get a divorce, a lot of times the law requires, or it's right in the divorce judgments now, that it's a required clause within the divorce judgments that your rights are extinguished to these things. So I'm not exactly sure if you can actually do an irrevocable, provision for life insurance issues.
Thank you. And then a follow-up question, same person is, what happens to property that is jointly titled when both owners pass away at the same time? Will it need to go to probate?
Yep. So that's a great question. So if you have a husband and wife who, say, pass away in a car crash together, they're both joint tenants with rights of survivorship, then everything would be going to probate. Hopefully they have a will so we know where it goes. And whatever's in their will would be probated, and then the probate process is transactional so that they can get things signed over to whoever was in the will. If there was no will, then basically the law determines who it goes to, and generally if they have kids, everything starts getting divided amongst the kids. If they don't have kids, it starts going up towards parents. If they don't have parents, then it goes towards siblings. That's kind of where that goes. But the big thing is, if they pass together, that's that's something that would go to probate. That's why it's important to have that will. So if they do go together, husband, wife, they know exactly where the house should go. One thing to be cautious about is a lot of practitioners have the husband and wife do a separate document. And that is because if, say, husband passes away and wife's still alive for 15 years, a lot changes in 15 years. And so if you do it as a joint document, things change. And so that limits the surviving spouse from changing a lot of things. And so a lot of times it's best to have two wills, for husband, one for wife, or wife, husband, whatever it is. But spouse one, spouse two should almost have separate wills, because if one passes away, then the other one can still make changes throughout his or her lifetime.
Thank you. And then the next question is, are IRAs asset protected in Michigan like a 401k plan from creditors?
They generally, I can just say this in general, they are protected with some exceptions. So, and they're pretty nuances in there, but generally they are protected. You know, especially if you have like, say, pensions or anything like that, a lot of times that's protected if you get sued. There are certain exceptions to it if you're trying to hide assets a lot of times or put it in IRA and stuff being out. There's certain ways to get to it, but they are they're more protected than just having money in a bank account. I'll say that.
Okay. And Stephanie is asking, what is a ladybird deed?
Good. So a ladybird deed is something that kind of takes effect upon somebody's death. So it says, hey, when I die, the house would go to my wife or my husband, whatever the case may be. So so when you have a ladybird deed, and it was named after, I guess, Lady Bird Johnson's the old story. But basically, once you pass away, then the deed kicks in at that time. So those are very dicey sometimes because some states recognize them, some don't. Those can get back. Those can be issues. One way to deal with that is to have a quit claim deed signed and never file it with the county or never record it, it's called. And then nobody's on notice that the deed exists, but yet it's still with all your papers. And as soon as you, I guess, pass away, your family quickly records that. And a lot of times families do it if there's an issue with creditors, things like that. So, but yeah, ladybird deed is something that happens after you die, then the property transfers at that point. That's really dicey though, sometimes because some creditors, say if you owed credit cards lots of money or something like that, that can be very dicey at times because then the creditors can say, well, I had my notice credited in before it transferred, and it gives them some room to kind of mess with your stuff. So not saying it will be successful, but give some room.
Okay, thank you. And then the next, I think we might have already addressed this, but just to make sure, if I have a child on the property as a joint tenancy, when I pass, will their bad credit affect the property before I pass?
Yeah, so that's a good question. So Gail, that's really good because in that situation, if they have some issues with creditors who are after their money and you're adding them to your house, you may be subjecting that house, especially if it's paid off, subjecting that house as one of their assets. So I would tell you really cautiously watch that. That's one of the pitfalls to that. For instance, you know, like I have three sisters, love them dearly, but my one sister, not the best with money. But I would never put her on my house for that reason. Because I'd be like, no, we're not paying for your fun and games you had when you were in your 20s. So no way. So that can have a negative effect. So really be cautious if you're going to add somebody that there's not somebody who can potentially take that. There are some protections for that if it's somebody's homestead, things like that. But you know, there's ways to work around it and to err on the side of caution. If there's some real credit issues, a lot of times it's best not to add them, especially while you're there. Now, if that's your only child and when you pass, that's something to maybe leave them and they'll have to deal with that when they deal with it. A lot of times at that case, I've heard before where, say, a child is left a house in the will and it's paid off, and now the creditors want it. The child can actually remortgage the house, so it's mortgaged. They can pay the creditor off and then keep the house, just pay the mortgage. So those are certain estate planning maneuvers or techniques that can be used. But that's an excellent question, Gail. Excellent. So, and I hope I answered. I think by the smile on your face, because you're one of the few people who's looking at me, I've been talking to the entire time. So I'm hoping that answers that.
Thank you. And then the next question is, what is the disadvantage of including my 15 and 17-year-old child as beneficiaries on life insurance?
Well, a disadvantage is a lot of times if they're not 18, then there's going to have to be something established for whoever's taking care of them to manage that money. So that could be a disadvantage, but that doesn't mean don't include them. What I would do is have life insurance documents. You have, you know, they're 15 and 17, so they're minors. So whoever their guardian is, I would get other documents for their guardians to administer things. Now, once your 17-year-old turns 18, they would get that money. So if you were to pass and they were 18, they would get that money. That wouldn't be an issue. But if you still had one who was a minor who was under 18, you know, that money itself would have to be administered by somebody. Hopefully you nominated a guardian. A big disadvantage to that is once they are 18, if you think your kids are the type to say, oh, wow, I got $10,000, let's go party, that may be an issue too. So that could be a disadvantage for the life insurance thing.
All right, thank you so much. Oh, another one got put into the chat is, do gift taxes have to be paid when adding a child as a joint tenant on a home?
No, generally not, because you're going to be under that, the 11,800,000 2015, then it rises for inflation so far. Generally, there's going to be no gift tax. Now, there could be, if it's your child, fine, but you got to watch. In Michigan here, we have, we got to watch about recapping our properties or uncapping the properties and our Headley amendments and things. So one thing of caution is when you put somebody on the house, make sure it is a close family member, because sometimes if it's a separate owner, then all of a sudden you do have some transfer taxes and other taxes, which aren't extremely high, but it could uncap the house. Because in Michigan, how property taxes work is once you own the home, taxes start getting limited. The mills start going down the longer you're there. But once somebody new buys the house, it uncaps, because everything gets capped each year and it goes down. Once somebody new buys the house, it uncaps it, so you're at maximum mills again. So generally with a close family member, it doesn't get uncapped if you're just adding them. So that's the advantage. But if you're adding somebody else, it could cause some of those issues.
And then Linda added, but didn't you give them over $15,000?
If you're just adding them to the house, it could be considered over 15, but it's not a tangible asset where they're actually spending money. They're not like gaining over 15,000. They're on the house. They're on titles on the house, but it is a transfer with close property. That's 15 for the year. But remember, your unified tax credit is 11,800,000 for lifetime. So you're exempt 15,000 a year just from just standard gift taxes. But generally after that, you still got your 11,800,000 for your unified credit. So you'd file that. I think it's Form 706 is what was in the presentation. And the big thing is if you do have some substantial assets and you are going to make a lot of moves, it is best to get somebody to actually do those documents for you because they can look at every little nuance of your situation and really give you the best advice there.
There's another question in the chat. Did you say traditional IRAs, Roth IRAs, and 401ks are protected from lawsuits in Michigan?
Well, they can be. So that was the thing. It gives you more protection than just having cash because certain pensions and retirement plans are protected. But the problem is with pensions themselves are much more protected. A traditional pension program is the best one. But the IRAs, the Roth IRAs, the 401ks, they're less protected, especially if you're hiding assets. So if you are getting, say, sued, there's the plaintiff can try to pierce that to try to get. They're not 100%, but there is more protection on them. They're not ironclad, I'll say that. So don't just think because in the IRA nobody can touch it. So that's the big thing. But there are certain things where they can get to that. That's why I suggested in the presentation too, if you property insurance, car insurance, to get an umbrella policy, because once you get that umbrella policy, if you are getting sued for whatever reason, and that umbrella covers pretty much everything, it's an umbrella. Once you get that, it covers anything, so it protects those assets indirectly. And generally, you get those, they're up to $1 million in coverage. So it generally protects any of your retirement assets. But they're not, I just want to make sure it's clear that those are not 100% protected under the law from lawsuits. But there are some levels of protection on there, better than just, say, a bank account.
Thank you. And then if anybody else has any questions, you can hover over your name if you're on the WebEx meeting and raise your hand. And we can take the questions. I don't see any hands going up, but someone put in the chat to me, where do you buy an umbrella policy? Can you
Through
repeat
your
that?
insurance. Yeah, sure. Through your insurance carrier generally. So most people do it through their property insurance. So I like my house is insured through Amica Insurance. So they got an office in Ann Arbor. So they offer umbrella policies. I also have like legal liability, malpractice insurance. I carry that. So you can do it potentially through professional liability insurance. So if you're, say, a nurse or a physician and you have professional liability insurance, a lot of times you can tack it onto that. Some do it through their property, but just ask your insurance carrier, even your car insurance potentially. You can ask them, how do I go about getting an umbrella policy? And normally they're very helpful because they want to sell you insurance. So giving them a call, they're the best resource for that. And then they price it out for you to say X amount of coverage is this. Normally it's up to $1 million, and they do that. But again, the advantage to that is if you get sued, it triggers that umbrella policy. You get the defense attorney or the lawyer because they don't want to pay out. So you generally get an insurance attorney to represent you, which kind of saves you more money and almost pays for the policy itself, I think.
Thank you. And then there's just a question. This recorded session we will forward out, and it will also be available on the CARE program website after it's been on there, after we're able to get the recording back, I mean. And then is Tanisha or
Yes.
hi, thank you. Did I say
Hi.
it correctly?
It's Tanisha.
Tanisha, okay.
Yeah.
So Tanisha has a question.
I apologize if you've already answered this question, but my mother and my husband are on the home, the mortgage, and God forbid my mother passes away, and my husband, does it automatically fall to me, or should they do like a quick claim deed to add my name to the mortgage?
Oh, well, okay. So good question. I'm glad you said that. Quitclaim deed goes to title. So keep in mind, title means ownership. Mortgage is separate. Mortgage is finance. Title is ownership. So quitclaim deed to put you on the house will put you on as an owner, but not necessarily the mortgage. So the mortgage has what's called a lien on the house to say, hey, we want our money back. And if we don't get our money back, then we can take that asset. It's a secured transaction. And we can take that and sell it. So they're already kind of a co-owner on the house as the mortgage. They kind of, as a lien, they're not really an owner, but they have a lien on the house. So a quitclaim deed would not accomplish what you want. Now, quitclaim deed would put you on as a co-owner of the house, so the title issues are dealt with, but the mortgage itself may still be an issue. You may still have to assume the mortgage because they're still going to want their money. The other thing is sometimes there's some type of mortgage policies or mortgage insurance. You pay more for it, but for somebody's untimely death, the mortgage actually gets paid. But I know that's some money to pay out to get that provision in there. But that may be something to look at if you had those resources. But yeah, just so everybody knows, the title or the ownership is separate from the mortgage. Think of the mortgage as, say, a credit card. So a credit card to buy a computer. I own the computer even though I bought it with the credit card. Now the credit card isn't secured transactions. They're going to want to come take that computer back, but they're going to want to sue you for that money. So kind of look at it as the credit card to pay for it, but ownership of that piece of property. So they are kind of, even though they're intermingled, they are separate. So
Okay.
just so everybody's aware that I want to make that clear. The quitclaim deed will not affect the mortgage. You could put 10 people on that, and the mortgage is still going to say, we want our money out of that house. We don't care how many people you put on that. We want our money. So yeah, that won't help you in that situation. But from what you're saying is you might want to ask your mortgage provider, your mom's mortgage provider, if there's some type of provision you can get for an untimely passing. And that may really satisfy everything, because if they do pass untimely and then, then it's paid off and you're added on, I think everything's been, satisfied at that point. That satisfy your needs.
Okay.
So
Thank you so much.
Oh, for sure. Check with them though.
Is anybody on the phone have a question? You can unmute yourself and ask your question.
And Veronica, I saw one just pop up. It says, what if I have a reverse mortgage? What happens with that at my death? Generally, if you reverse mortgage, that means you're basically giving title to the mortgage company. So generally they're going to get it, is how they write those contracts up.
Oh, I had a message come in to me and it says, it's from, does the owner of the mortgage loan company have to be notified when someone is added to the title?
Ah, that's a good question. Take a look at your policy. Some will require that, some won't. So it's very specific to your policy. So or your mortgage contract. So take a look at that. If it's required to advise them, let them know. Sometimes reading those things, I'm a lawyer and I hate reading that stuff. There's a reason I do criminal defense. I hate transactional law. I can't stand it. There's a reason I don't do probate. I like doing these presentations to help people out, the basic stuff, but I hate probate law. I don't like it. It's all transactional. And I love criminal defense. It's in the courtroom and dramatic. But at the same time, you can call them up and ask them because they'll tell you right what's in there, and they can point out the provision exactly where to look. So yeah, definitely call them up to ask that question because it just depends on the contract.
Are there any additional questions?
So
Oh.
Gail's got one.
Yep, Gail. Oh, you need to unmute yourself, Gail.
Can you hear me?
Yes.
Okay. This is not related to that, but Dennis, can I have your phone number to ask a question in what you do criminal justice wise?
Yeah, I'll just put it in the chat. Can you see the chat?
Yes, I can get to it.
Okay, I just put it right in there.
Oh, thank you.
For everybody, it's 313-365-0258. And that generally, my office goes to my cell too, so it's textable too if anybody needs a text. That's not a problem either.
Are there any other questions?
And Veronica, if I could, it looks like the
Sure.
questions are done, but I just want to point out to everybody, your specific situation, everything, especially in probate, is so tailored to your situation. So if you are looking at making a move or doing some of these things, I definitely recommend, even if you don't consult with Amy Ruby, consult with somebody who concentrates in this area. Even if you have legal insurance, if you're a Henry Ford employee, you have the legal insurance that you get through the benefits, they have people. Talk to somebody specifically long-term about your situation who can sit down or sit on the phone with you so that everything is tailored to exactly what you want, because a lot of this I guess, general information, it's very broad. And so there might be certain things in your circumstances which could trigger other things that not be covered in this presentation. So I just want to make sure everybody's aware that this is overall education, so we have an awareness. But if you're looking at your specific circumstances, definitely reach out to somebody who's licensed and who concentrates in this area, and definitely talk to them about it, because I don't want somebody to sit there and say, well, I went on the presentation, I did this or that, and then your circumstances would have called for something else. I want to make sure nobody gets hemmed up in anything. That's all. And then there's legal insurance through Henry Ford. So I have coworkers that enroll in that, and it's very good for things such as transactional stuff, probate, for good questions. And they give you attorneys who actually specialize or concentrate in whatever area you're looking at. So sometimes that's a very good investment for people. And I've known people who've gotten that and who have been very happy with the Henry Ford legal insurance. If you're an employee, if you're not, reach out. If you are actually low income, there's an estate planning clinic out at the Cooley Law School, and it's law students supervised by professors, but a lot of times they're a very good resource as well for more low income. And they can help you out with that stuff too, because they're concentrating that, and that's all they do. Thanks, Veronica. Sorry.
All right. Excuse me, I have a tickle in my throat. So I want to thank everybody for coming. Yes, we will send out the presentation once the recording is available. You will get the recording as well emailed out to you, and then should have it to post on our website too, so you can look at it later. You're also getting a Survey Monkey sent out to you regarding feedback on this session, and we really welcome your feedback. And Dennis, I really want to thank you again. This is just so helpful, and Really appreciate your time and you being here, and looking forward to seeing you on Wednesday night as well in the second session. And appreciate everybody who took time out of their day to come. And I hope you found it valuable.
No, pleasure being here. Thank you all for joining. I'm glad we had a big group today. Thank you.
Thanks, everyone.
See you Wednesday.